All right. Sir, is your name Michael? Is it Fasco?
Yes, Your Honor.
Is that the correct pronunciation?
Yes.
Okay, great. Thank you. We're on the record now in Fasco versus the Secretary of State. This is case number 2419697. We have Mr. Fasco, who is the petitioner, connected by Zoom today. We have Mr. Rolla present on behalf of the Secretary of State, also by Zoom. Mr. Fasco, this is your appeal of the Secretary of State's determination upholding a revocation of your driver's license. And so today is the opportunity for you to state for the record your argument and support. I think we have a timeliness issue. I don't know, Mr. Roll, if you're going to address that, but
I will, Judge.
okay, so the court would have to find that there's good cause for the late filing of the petition. And then if the court finds that there's good cause, then in order to overturn the Secretary of State decision, the court this is not a de novo review. In other words, I'm not making my own independent decision about whether or not your license should be restored or you should be granted restricted privileges. The court is reviewing the Secretary of State's determination to determine whether or not it's supported by competent, material and substantial evidence on the whole record, that it's not based on some type of error or law, or that it's arbitrary or capricious. So, Mr. Fasco, do you understand kind of the basis that I'm looking at this from?
Yes.
Okay. So, Mr. Rolla, I'm going to have Mr. Fasco state his position first, and then I'll give you an opportunity to respond on behalf of the Secretary of State. So, Mr. Fasco, first, if you can address the good cause issue for the late filing of the petition.
The good cause is that actually, when I started this process, I was living couch surfing, as you may call it, at a different address in a different county. And then when I found a permanent residence where I am now, the paperwork is actually one of them that should be in your copy to where it was the other courthouse, and the paperwork was filed in a timely manner. And during this process, we had found out that it had to get moved to Otsego County, which then I was given the paperwork from the Secretary of State to switch it over, which is the other document from the Secretary of State that told me to bring it up to the Otsego County Courthouse. It got a little bit delayed farther in the filing process. But everything was taken care of at the county clerk's office as timely as it could. But the petition was actually originally, here's a date from it got moved again on the bottom of the one copy from May 13th. And the paperwork was in well before that. That just happened to be the day that we were in the courthouse on this issue the first time.
Okay. All right. Thank you. And then with regard to the ultimate issue here, which is the Secretary of State upholding your license revocation, your petition just kind of really addressed the issue of the late filing. So what error are you claiming, or what are you saying that was wrong about the Secretary of State's decision?
Well, inside their decision on their order of action, multiple times it states in their very beginning part of it that underneath the Rule 257 313, number 1 has to prove that the petitioner has the ability to drive safely and within the law and will remain under control. Well, later down in the same statement, he addresses that on the part, and he says he is motivated to drive safely. There were other spots, but the main one is right there, because that's the grounds of which I was not allowed a restricted license. But it states in the paperwork that I had proven that by their own discretion. And with all the other cross sections that I have to adhere to, or it says requirements on the last page, it clearly states throughout the order of our conversation that I had actually met all of those requirements. That the key situation was, would I be motivated to drive safely? It says under, would he likely to remain under control? Would that the petitioner repeating his or her past behavior is at lower minimum risk, that the petitioner has the ability and motivation to drive safely within the law. So later on, before it gets to the very end, it states that I am. And even in my prognosis from the medical doctor, which should be on this one, they state the same exact statement.
Okay, thank you. Anything else that you wanted to state regarding errors in the Secretary of State's determination?
At this present time, I believe that that's really, that's really the only thing that really concerns me, because I understand that I did break the law. I have taken full responsibility for my actions, and that I have definitely fulfilled all the requirements. I also do know that there were some other discrepancies where it says that my medical doctor didn't write anything about my other drug usages, but it actually clearly states back in her prognosis paper, it actually does state all that right at the very dead top of it. That even my cross section of people have been people that I have known in the past, present, and in the future. And if I can also state on record that I was also within that it wanted statements from people who knew me in the past, which I'm really unable to obtain because I've changed my life and I'm no longer around the toxic environment. And I guess that's all I have, Your Honor. I just hope that there's some clarity on some key issues that have been obviously misunderstood or overlooked by the staff.
Okay, thank you. Mr. Rolla.
Yes, Your Honor. For the record, I call on behalf of the state of Michigan in this particular case. A couple of things I think need to be brought forward. First off, the reference I believe that Mr. Fasco is referring to was a letter following his hearing date of November 28, 2023. And although it indicated that he should be motivated, as he indicated, to drive safely, he has an unresolved drug crime in Florida. He has the situation where, although he had letters addressing his abstinence since April 21st, since April of 2021, it did not address his marijuana use after that time, specifically indicating at page 3 of 5 of the rejection in the order that he indicated he was a daily user. Now, maybe he's not doing that. Maybe he is. I don't know. But again, Your Honor, I don't think that's the biggest problem for the court. I think, quite frankly, those are minor issues. I think the biggest problem from the court is, as indicated in the Secretary of State's letter from July, I want to say it's the 17th. If you give me a minute, I'll pull it up. There is no transcript that the defendant is required to provide to the court so that the court can make the necessary findings it has to. It's just not provided, and as set forth in the letter that was sent to Mr. Fasco from the Secretary of State, they told him he had a late request. He had to prove hardship for a late request, and even if he could prove hardship for a late request, before the court could grant it, the court would need a transcript in order to review to be able to do it. And I don't know if the court's got a copy but our office was not provided with any transcript or any copy of any transcript. So I don't know how the court can make the requisite legal finding. Thank you, Your Honor.
All right, thank you. Mr. Fasco, this is your petition. I will give you the last word. Is there anything else that you wanted to say today in support of your petition?
I just would like to address back to the issue that he said. Yes, it doesn't say anything about marijuana usage, because the fact that I had been drug free from marijuana for years back on the statement, it is shows that that was back in 2015. I was asked if I had ever used, and I was truthful in what I had said, that my drug tests have proven that even when this offense had happened, there was no drugs in my system. I've continued to stay clean from absolutely every drug. And referring to the paper, the transcript papering, I have yet to receive that. It may be due to I have had 3 separate addresses since all of this is first started. And I know that every now and then I get Secretary of State paperwork from the address that I originally left the rehabilitation center from, and every so often they give me my papers. I'm not sure if that is the case, but I'm sorry for the miscommunication on that, and I'm just asking for relief so I can continue my life and my walk.
All right, thank you. So prior to today's hearing, I did have a chance to review the file. I do note that there was not a transcript of the hearing before the hearing officer provided. However, there were the exhibits that were attached to the petition. And so the court's going to, by statute, the court's required to limit its review to the record that was before the hearing officer. And I'm going to go on what was provided to me here for purposes of today's hearing, which was the exhibits and the ultimate decision, although there was not a transcript again provided. The first issue, as I indicated, is whether or not there's good cause for the late filing of the petition. I do find that there's good cause here. I think it's clear that Mr. Fasco did try to file his petition in a timely manner where he thought it should have been filed. I can accept that the rules regarding filing of these petitions are kind of complicated, and I think it would be really easy for someone trying to navigate this as a layperson to file it in the wrong county, in the county where the conviction was, as opposed to the county of residence. So I don't think I can fault Mr. Fasco for that. I think that's a common mistake that anybody could make in trying to navigate this system. So the court finds that there's good cause for the late filing of the petition, so the court will consider it on its merits. In terms of that, the underlying issue for the hearing officer is that the court or the hearing officer has to find by clear and convincing evidence that the petitioner, Mr. Fasco, has proven that his alcohol or substance abuse problems are under control and that they're likely to remain under control, that the risk of him repeating his behavior is low or minimal, and that the risk of operating a motor vehicle while under the influence is low or minimal, and that the petitioner has the ability and motivation to drive safely and within the law. So there are essentially 4 different considerations that the hearing officer has to look at. And then, as I stated at the beginning of the hearing today, my review is limited, again, to the record before the hearing officer and to simply a review of the hearing officer's decision to determine whether it's authorized by law, whether it's supported by competent material and substantial evidence on the whole record, and whether it's an abuse of discretion or arbitrary or capricious. And that means that even if I, looking at the evidence, would have arrived at a different decision, or frankly, even if I think the hearing officer was wrong, as long as his decision or her decision is supported by the evidence and not contrary to law, I can't substitute my judgment for that of the hearing officer, and the court has to uphold the hearing officer's decision. In this case, number one, the court finds that the hearing officer did apply the correct law and standard to the issue before the hearing officer. And so the court finds that the decision is not contrary to law or outside of the law in some way. The real issue is whether or not it's supported by the evidence. And in this case, it's clear, and the court's looking at particularly page 3 of 5, that the hearing officer had issues with Mr. Fasco's credibility in terms of how long he's been alcohol and drug free due to conflicting statements between what was filed in writing, indicating that he had been drug or alcohol free for 5 years, and his statements that it had been since 2021, April of 2021, the time of the offense. And so the hearing officer found that there were some credibility issues and that some of the evaluations that he had, which did indicate a very good prognosis, weren't based on completely accurate information. And so therefore, those evaluations, the weight of those evaluations was less than it could have been. And while the hearing officer found that Mr. Fasco did meet some of the requirements, as Mr. Fasco indicated, that he had the ability and motivation to drive safely and within the law, I think it's clear from the hearing officer's decision that the concern was some of those other factors, that the alcohol or substance abuse problems were under control and likely to remain under control in particular. And again, that's based on the conflicting information that was given. And credibility determinations are something that are really within the province of that hearing officer. And so the court finds that, again, regardless of whether I would have reached the same conclusion or not, the decision was supported by competent material and substantial evidence on the record and was not arbitrary and capricious. So for those reasons, the court must uphold the determination of the Secretary of State in this case. And Mr. Rolla, as the party appearing on behalf of the Secretary of State, if you could just prepare an order reflecting that the court, for the reasons stated on the record, is affirming the decision and submit that under the 7-day rule.
I can, Judge. One thing in the letter I was referring to, the date on it, that's the July 2024 letter from the Secretary of State from Office of Hearings and Administrative Oversight. And it indicates actually that as of July 15th of this year, no request for the transcripts even been received by the Secretary of State. So
Okay.
in any case, I just thought I didn't let Mr. Fasco know that. So if he's going to try and do this in the future, according to the Secretary of State, they haven't received any request at all for a transcript.
Okay. All right. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Judge, while we're still on, I want to make sure I got Mr. Fasco's correct address, so I will know where to send a copy.
Mr. Fasco, can you give us a current address, please?
14973 Spar Road, Johannesburg, Michigan, 49751.
Thank you.
Nope, thank you.